in a criminal procedure. However, I am alive to the fact that in the case of Wambora, Civil Appeal number 24 of 2014, the Court of Appeal did mention that governor's impeachment proceedings are sui generis in nature. Sui generis in nature in the sense, Honorable Chair, that the rules as we know them in civil procedure and criminal procedure are not so static in these processes because it is a fact-finding mission. And such, Honorable Chair, I find the objection unfounded on the point that the governor cannot choose to look at the particulars as against the evidence. In any trial, and this is a quasi-judicial trial, there is always the particulars of charge framed in a manner that is so precise, so clear, and so concise for the person being charged to understand the particulars. He cannot then take the motion and juxtapose it, suppose the same as against the evidence. When we were invited by the Senate, via a letter dated sorry, I'm trying to find out the date. When we were invited by the Senate, though, by a letter dated the 17th of June, this House was alive to the fact that the motion must be traced and must be supported by the evidence, and as such, evidence was then called thereto. The statements being impunged, or the statement being put under trial, is that of the mover. He has adduced evidence to answer charge of the governor undermining the authority of the assembly. Unless the governor wants to convince this committee that the motion itself is a full house, full contained with the particulars of evidence, then that would suffice. But it would be in violation of Article 50 of the Constitution for him to choose to look at it from that perspective. Article 50, which is overriding to these proceedings and which is binding to these proceedings, has created an avenue for parties to adduce evidence so as to prove their case. Honorable Chair, as I sum, you have been invited to look at our evidence as additional evidence. The evidence before you in that bound document is the evidence that was used to prosecute the governor at the County Assembly of Kirinyaga. Suffice to note that despite or in spite of an invitation being extended to the governor never responded. The governor even never wrote a letter back to the County Assembly saying, I am not able to attend to the trial. This is an afterthought that the governor has brought up. He's clinging on very, very weak grass. And we urge the committee to apply the oxygen principle, which provides that in a committee of this nature, which is